Good morning, everybody. Let me welcome you to Madrid, to the Carlos III University. Welcome to this exciting event on the outer limits of antitrust law. I hope those of you who have traveled here enjoy your stay in Madrid. In recent years, the debate has intensified as to whether competition law should pursue not only the protection of consumer welfare, but also, or instead, other public goals. Leaving aside the purely doctrinal debate, some governments in Europe, especially after the banning of the proposed acquisition of Alstom by Siemens, have called for the European Commission, the European Competition Authority, to be subject to supervision by the governments of the member states, at least when it takes decisions that may affect national interest. Along the same lines, some national laws have moved in the direction of softening the enforcement of the prohibition of cartels to sustainability agreements, and the issue is now being addressed in the Commission's draft horizontal guidelines. And even before that, some competition authorities, at least here in Spain, impose on a regular basis behavioral obligations aimed not only at bringing infringements to an end, but also at regulating what they consider to be market failures. So the question is, should agencies limit their role to protecting and promoting consumer welfare? Or should they consciously address, in addition to or instead of, other social concerns? Can they do so effectively? Or are there more appropriate means? How would it affect the independence and accountability of competition authorities? How would it even affect the rule of law? Would antitrust law be clear and anticipated by stakeholders? To discuss the relationship of antitrust law to sustainability, to the political power of dominant firms, or to industrial and social policy, a truly impressive cast of academics, practitioners, and regulators have gathered here today. Thank you, all of you, for coming. And thanks, of course, to Jeffrey Mann, to Lathar Radic, Charity Williamson, and all the people of the IECLE for making it possible. It has taken a little longer than initially expected when Lathar contacted me 1 year ago now, but I'm sure it will be worth it. Without further ado, I give the floor to Lathar. Thank you.
Okay, so first of all, I would like to thank the Universidad Carlos III and especially Professor Antonio Robles for their support and for allowing us to host a conference in this renowned academic institution. I would also like to thank everyone in attending in person, which I think is about 40 or 50 of you, not a full house, but almost. And in addition, I'm happy to say that we have around 100 people watching us from home. So to all of you watching us from home, we haven't forgotten about you. I like to use these long 5 minutes to briefly paint a picture of the concept that has inspired this event. So as you may imagine, the ship that you see on the graphic is exploring the outer boundaries of competition law, as the title of the conference suggests. Now, what you may not know is that this is actually meant to represent the ship of Theseus. According to legend, Theseus was the mythical Greek founder, king of Athens, who slew the Minotaur, rescued the children of Athens from King Minos, and then escaped onto a ship to Delos. Each year, the Athenians commemorated this legend by taking the ship on a pilgrimage from to Delos to honor the god Apollo. After several centuries of maintenance, however, a question was raised by ancient philosophers, always inquiring and asking questions. If each individual part of the ship of Theseus has been replaced one at a time, was it still the same ship? Much like Theseus' ship, there are increasing calls today for parts of antitrust to be replaced, removed, or for new parts to be added. In today's event, we have decided to focus on three such metaphorical planks of the antitrust ship: democracy, sustainability, and industrial policy, in exactly that order. Ultimately, the question that we hope to explore today is, at what point does antitrust stop being antitrust and become something else? What can be changed, what can be removed, and what can be added, if anything, or how much of it? What is the essential core of antitrust, which, if removed or substantially modified, signifies the unequivocal transformation of competition law into something altogether different? I'm certain that today, with our brilliant roster of speakers and audience aboard the ship, we will come much closer to answering these important foundational antitrust questions, or at least much closer than Theseus ever did. Now, I would like to give the floor to our keynote speaker, Maria Pilar Canedo. Maria Pilar Canedo is counsel of the Spanish Competition Authority, the CNMC. Prior to her work at the CNMC, Maria Pilar was president of the Basque Regional Competition Authority. She's also a renowned professor of law and has published extensively in the field. She has been, in addition, director of a variety of renowned academic programs, both in Spain and abroad. Maria Pilar. Great.
Thank you. So I wanted to begin underlying the issues that are going to be developed in the seminar. And I wanted to begin with those main ideas because I am going to give my personal opinions, and I didn't say it in the beginning, but the opinions that I am going to share are personal opinions. They don't bind the institution where I am working now, which is the CNMC, as you heard. But there are those issues that I wanted to begin with. Is political power an antitrust problem? And we will have a whole session of the seminar discussing these things, but I wanted to begin underlying something that I think is quite relevant from our perspective, from the perspective of the competition authorities, which is that because of the different crises that we are experiencing in our society, the disruption that happened because of COVID, and also after this because of the war, we are experiencing, I was going to say suffering, but I will say experiencing, a trend of protectionism. And I think that this is something that we need to keep in mind because it's universal, I would say. And then we should consider why is this happening and how competition authorities should deal with this new trend. I would love to say that political power is something absolutely independent from competition authorities or from the antitrust community, but this would not be true, I think. We need to be aware that when competition authorities work in order to offer services for a society, and society is affected by different situations and different trends, and we need to keep those trends in mind if we want to offer efficient answers to our society. So I guess that we should make a serious analysis of why these kind of trends happen and how we should deal with this kind of new approaches, new political approaches to our society. Because I guess that those protectionist movements happen because lots of people in our society feel that the development of the economy and the development of liberalism in a certain way has had a negative implication for certain parts of society. And there are lobbies of companies in my approach and lots of political parties that are using this sense that lots of people have in our society to try to stop the development of antitrust. And I think that this is something that we cannot hide. We need to be aware of this situation if we want to be efficient and offer efficient answers to our society. And then I wanted to talk a little bit about what we are doing in our competition authority, because sustainability is, of course, something really relevant. We cannot apply competition law in a vacuum without taking into consideration what is happening in our society. And that's the reason why in our agency, we included sustainable development goals in our strategic plan. And we are trying to develop the concept of sustainability that we want to apply in our decisions, and the concept that we want our decisions to be informed with. And when we are talking about sustainability, we are not just talking about environment. We are talking about environment, we are talking about social inclusion, we are talking about economic sustainability. So what we consider is that perhaps we don't need to change all the tools that we have, but those principles should be considered when adapting our policies. I mean, competition policy is, of course, one of the public policies, and we cannot be outside all those trends. So we need to be aware of those concepts, and we need to be very careful on how those concepts are used. Because in our constitution, in our legal system, we have legal grounds for including those principles in our policies, but without losing a very relevant idea from my perspective, which is that the goal of competition is to look for economic efficiency and consumer welfare. And those are, of course, concepts that are very broad. We can define economic efficiency and we can define consumer welfare in very different ways, but we need to include, we need to fulfill the content of those concepts using those new sustainability principles that we are being asked by our society. And that's what we are trying to do. Keeping in mind something that is, I think, really relevant from the perspective of a competition authority, which are the principles that are written down in the slide, which is legal certainty. I mean, when we are talking about this, the implication, the use of those new principles, we need to be very careful because our decisions need to be foreseeable. So we cannot change from night to day the approach that we are giving to certain behaviors. From the perspective of a competition authority, respecting the principle of legal certainty and legality and prior definition of offenses with a very specific control is really relevant, because we are, of course, and this is needed and really relevant, subject to judicial control. So if we take decisions that are not foreseeable, and the companies will complain, and I think that they will complain with a reason. And then with those principles in mind, how competition law contributes to sustainability. And I think that improving technological innovation is something that comes together with competition. We are the competition community, and we are so used to be aware of the impact of competition, the impact of new companies into society, and the innovation and the technological innovation that competition takes with it. And promoting competition comes with lots of very sustainable objectives to society. I mean, the traditional application of competition law implies those benefits for society, and those benefits are very sustainable if we take these broad concepts of sustainability, including social, economic, and environmental sustainability. Are we doing something else? Of course, we are doing lots of things. When competition is working in an efficient way, we have better access to goods and services for vulnerable consumers. When we are talking about social sustainability, we are talking about the implication of services, public services, but not only public services, also private services in cheaper prices, in better quality. And when we are talking about the application of competition to public procurement, for example, this has a very relevant implication for those vulnerable consumers that would not be able to access lots of services in a relevant quality, in a certain level of quality, if the administration, if the government is not able to give those services. So I think that this is the access of cheaper and better goods and services for every citizen in a society, I think is something that we are doing in competition authorities. And job creation and increasing of productivity is also something that we need to underline. When a market is not competitive, the job creation is much slower and the quality of the work is not so high. We need to, of course, pay attention to agreements of companies that go against the interest of workers, and we have the no-poach agreements. But we are underlying the approach that we do to this kind of behaviors that go against public interest, and I think that this is something that is quite relevant from a sustainable approach perspective. And then we encourage with our activity different innovative business strategies. And I think that perhaps I'm a little obsessed with this, but I think that the connection of competition authorities with the administration and how the administration is offering services to the public is really relevant, and the relation with regulation and the analysis of regulations that create burdens for companies to enter in the market and to innovate in the offering of services is really relevant. And I think that we should underline this. How doing this? The first option is what I think we are doing in competition authorities. I'm seeing several representatives of competition authorities in Spain, not only the CNMC, because you know that there are regional authorities in Spain. We have a decentralized system, and I think that the work of regional authorities in this analysis of regulation, of local regulation and activity of the administration is really relevant. So I think that underlying the positive effects that decentralization of competition law enforcement in Spain is something that we need to do because we are proud of our system. But increasing the visibility of those activities is something really relevant. We in the competition authority are doing lots of studies, making analysis of the legal system and trying to adapt our legal system to this new reality. But we should also considering adapting the decisions that we take according to those principles. And we could do it quite easily with prioritization. We didn't have prioritization in the Spanish legal system until quite recently. We included it thanks to the application in Spain of the European Union directive. And now with prioritization, I think that we could show society that we are going in a direction that comes together with the respect of those principles. But I think that some things are relevant to underline because we can do it in state aid, we can do it in merger analysis, we can do it in enforcement, and this is something that goes together with the work of a competition agency, no matter which is the field that we are analyzing and the tools that we are using. But we need to be aware of this slide that for me is really relevant, and for me is, I guess, the key point of my speech, which is that we need to be very careful because those very nice concepts and principles cannot hide that there are spurious uses of those concepts, that in a relevant number of cases, the companies try to go using the companies or the administration creating rules, use those very nice concepts that no one contests because they know that no one contests. But the real reason why they are entering in certain behaviors, or the reason why the administration is including certain burdens into regulations is not in fact the protection of sustainability, but particular interests that can be hidden back those big concepts. And I think that this is something that we need to keep in mind, together with the problems of application of those big concepts, because I mean, talking about sustainability is really easy, but the application, the specific application of this principle in particular cases needs determination. I mean, we are talking about efficiencies. How are we going to measure those efficiencies? I mean, saying this is efficient is not enough. We need to really make a balance of the burden and the problems created together with the efficiencies, and we need to weigh the costs and the benefits that a particular measure or a particular agreement creates, and then we can face different approaches, different interpretation, and this is something that I think we need to keep in mind, and we cannot hide that sometimes we are facing, I mean, lobbies of companies convincing the administration to create certain burdens in order to protect their own interest instead of protecting public interest. My approach to this situation is that we, competition authorities, need to protect public interest. And this is something that, of course, again, it's another broad concept that needs interpretation, but this is something that we need to keep in mind. We need to work together in order to look for a particular definition of this concept. Do we need to change something? From my perspective, those three elements are really relevant, and that's why I wanted to underline them. Predictability is key for the work of a competition authority. If we are going to make changes, the companies, the undertakings, the society, the administration needs to know what we are going to do. So predictability is really relevant. An international, in our case, more relevant European Union, but international coherence is something also very relevant, because competition law is universal. I mean, we apply competition law everywhere with small differences, with nuances everywhere, but we have more or less the same principles. And now we are all discussing about those topics, and this conference is one example of this concern. So I think that going together, working on international organizations, working together in the European Union, I think would help this predictability and would help finding answers that go in the correct direction, protecting general interest. And then I would like to underline, because I am a competition law person, I would like to underline the relevance of competition for the markets. I mean, we have lots of other goals. We are going to discuss about lots of other goals today, but I think that competition in itself is a very relevant goal because it creates lots of benefits for society. And that's something that I would like to underline. And together with this, we need to be aware of the problems. We cannot use these kind of agreements to accept cartels, to authorize mergers that are just based on this. So we need to be rigorous in the application, in the enforcement of competition law, with traditional tools, and also considering state aid. And for this guidance, the horizontal guidelines are really relevant. And then I wanted to underline that there's a discussion right now inside the European Union with the member states trying to define what is the approach that the European Union is going to consider dealing with these kinds of agreements. And those cumulative criteria that are right now included in the discussion, I think are really relevant because they show that the approach that the European Commission is offering now. Let's see what the discussion is with the member states and how the different approaches are reflected into the final document. But I think that these cumulative requirements that the Commission is including in the guidelines in order to consider that an agreement can be accepted, I mean, going beyond the traditional rules shows that the European Commission is going in a very prudent direction, not following some of the member states, and I think not the majority of the member states, but those countries that want to go with a much broader concept of sustainability and trying to accept behaviors that could go against the traditional rules of competition law just because they protect sustainability. And I think that this approach, this is a personal opinion, not the one of the European, not the one of the CNMC, because we still didn't discuss about this in the board, but I would say that this prudent approach would be quite reasonable. And then I wanted to show a case. I only have 1 minute, but I wanted to mention a case that we solved in the Spanish Competition Authority that shows a little bit how those criteria of sustainability can be misused by companies. And I wanted to explain, well, to mention, not explain because we don't have time, the case of harbor stevedores in the Spanish ports, because we had a legal system that created a historical privilege for a a small group of workers, and those workers tried to convince the administration that their privilege was in favor of general interest. And at the Spanish Competition Authority, we used many different tools. As you can see, we used enforcement because we had a sanctioning case. We had advocacy because we made analysis of the collective bargaining agreement, and also advocacy with the administration because we were making an analysis of how the law was drafted in the Spanish legal system in order to try to show which of the rules that were included in all those behaviors and rules were in fact protecting workers, and which of those rules were just respecting a historical privilege, avoiding different workers to enter in the market. So I think that this is something that could be interesting considering our approach. Then my last slide goes with advocacy of competition and the analysis of regulation based on the principles of necessity, proportionality, and non-discrimination that I think are key. And we have lots of examples of rules that create problems in competition, sometimes based in those sustainability principles, but sometimes not respecting them in fact. And that's everything I wanted to say. I respected my time, so thank you.